Hi, I'm Ryan with the R&R Law Group. Today we're answering the question of what happens in my felony not guilty arraignment in Maricopa County. So a lot of people have a lot of questions about this. Some people are very scared, nervous about going into court. The not guilty arraignment is generally your first court appearance that you're going to make. This is after you've received a summons in the mail that says that you've got a felony charge against you and you have to show up to court. So Maricopa County, not guilty arraignment. It happens in the South Court Tower, which is at 175 West Madison, downtown Phoenix. The third floor, courtroom 3C. So there's a lot of parking downtown, but I always tell people that understand that if you're parking at a meter, this could take a couple of hours, so just be prepared for that. So the very first thing you're going to do is you're going to check in at the information desk. So as you go up to the third floor, the information desk is directly across the lobby from courtroom 3C. Normally around 8 o'clock in the morning there starts to form a real long line. So you're going to get there, you're going to go through the line, you're going to fill out the paperwork if they have paperwork for you, and then you're going to go wait and sit outside of courtroom 3C. Courtroom opens at 8:30, so as soon as it opens, then you want to go inside the courtroom. Understand it's not a handful of people that are going to be there. Sometimes there's 30, 40, 50 people that all have not guilty arraignments that morning. There's also some in custody people that are going to have their not guilty arraignments that morning as well. So that's why I discussed the fact that it could take a couple of hours before you're going to get called and go through that. The judge is going to come out. The judge is going to do a group advisement. So he's going to tell everybody that if you're there for a felony, you have certain constitutional rights. He's going to go over all of those constitutional rights with you. And then he's going to go over the range of possible penalties for the different felonies that are there. So everything, from a Class 2 felony down to a Class 6 felony, all of the possible penalties that are available if you are sentenced for that level of felony. Next, you're going to wait to get called. So this is where it could take a while. It just goes in number from 1 to however many are on the docket. And it just depends on where you fall on that number as to when you're going to get called. You're going to go up and either stand next to your lawyer or you're going to stand next to the public defender. Understand that the public defender that's there that day represents everybody for just that one hearing. That's not going to be the public defender that's assigned to you. That person's going to get assigned generally in 7 to 10 days after that court date. So you're going to go up, stand next to them. The judge is going to tell you exactly what the charges are that are being levied against you, and make sure that you understand that. And then they're going to talk about release conditions. So if you were previously arrested on this, you might have already posted a bond, and the judge will just affirm that current bond and then move on from there. If the judge doesn't do that, then the attorney's going to talk about release conditions for you. A lot of the times it could be an own recognizance release, meaning that you just promise to show up to the next court date and you're going to be released just the same way that you walked into that courtroom. Sometimes the judge will order pretrial services with drug and alcohol monitoring, or just pretrial services, which means that you're going to have to check in with somebody after you leave the courtroom that day. Whatever the release conditions are, you're going to go over then and sign for the release conditions. That's the last thing that you're going to have for that not guilty arraignment in the morning. So you go over, you sign for those release conditions. If you're assigned to pretrial services, you're going to have to go visit with them. They're over at 620 West Jackson, a couple blocks to the west, and just make sure that you get everything squared away. So one of the questions we have is, well, what's an attorney going to do for me at that not guilty arraignment? Well, one thing is generally we can get you called quicker. So at the front of the line, go in, be able to call the case, and then move on from there. The reason for that is because we will go over your constitutional rights with you, as well as your specific charges and everything else. So we can kind of expedite the process for the judge, so the judge will move those things at the beginning of the day rather than have to sit through the group advisement and go through everything else. So that'll just move things a little bit quicker. The other thing I talk to clients about is, you want to get your attorney on as quick as possible. So, the public defender that's there with you that day, not going to be your assigned attorney. They're going to wait another 7 to 10 days before you're going to even know who's going to be handling your case. We want to get to work right away. Usually we get discovery or the police reports or any investigative reports the day of your not guilty arraignment. If they're not available that day, the judge orders the prosecutor's office to make it available within 5 business days. So that's still, 2 to 5 business days before your attorney is going to be assigned to your case. We want to be able to get everything so that we can start diving into your case, get the police reports and all that information over to you so that you can go through the police reports with us, and then we can start working on the case. So it is important to have an attorney there, especially if there's going to be any argument as to your release conditions, because we can talk to you ahead of time, make sure that we understand everything about you, how long you've lived in Arizona, your job, a lot of other factors that can go into play when arguing your release conditions, so that we can attempt to get you released on your own recognizance. Again, that means you don't have to post a bail. You don't have to report to pretrial services. It's the easiest of release conditions. That's what we want to obtain for all of our clients. So if you have any questions, or you've received one of those summons in the mail, you've got a not guilty arraignment coming up, give our office a call. We can talk about it, see what's going on, and make sure that you're settled and ready to go to your not guilty arraignment. If you have any other questions, or you've got a question you'd love to see a video about, post it in the comments, and we'll be sure to address that topic as well.